Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. Good afternoon. My name is Kiara and I'm from the Community Legal Education team here at Legal Aid Queensland. Apologies, I am off camera. Thank you for joining us for the final webinar of 2025. Today's topic is supporting people appearing before the Mental Health Court and Mental Health Review Tribunal. A webinar will be presented by our lawyers Ethel and Lorraine. Just a little bit of housekeeping before I hand it over to our presenters. This webinar is being recorded. The laws and content is accurate on the day of the live presentation and may change. Information is on our Community Legal Education Resources page on Legal Aid Queensland's website. For any technical help, we are unable to help you and you will need to reach out to the GoToWebinar customer support team. A little change to today's webinar structure. We actually will not have a Q&A. We will have a full presentation. If you do have any questions following the end of the webinar, please send them to webinars@legalaid.qld.gov.au. Or you can also reply to the email that you'll receive at the end once the recording is ready to go onto YouTube. You can access a copy of the PowerPoint slides in the download handout section just on the bottom corner, but you'll also receive an emailed copy of the slides as well. All right, so just 2 quick polls to get us started to see who our audience is today. So our first poll is which region do you work in? So the options are Southeast Queensland, Far North Queensland, Regional Queensland, and outside of Queensland. I'll just give a few moments. All right, wonderful. I might shut that off. And so our results are 65% are from Southeast Queensland, 3% are from Far North Queensland, and 32% from Regional Queensland. So we actually have no one outside of Queensland today. Hopefully that helps with the content that you'll be presenting. Right. And just our last poll, what is your role? Support worker, financial counsellor or health education worker, social worker, lawyer, or other. And I'll just give everyone a few moments to respond to that. Just another couple more seconds. All right, I might close that one out. So the results for that one, we have 11% of support workers. We don't have any financial or other counsellors, 9% social workers, we have 41% for lawyers, so a large chunk today, and 39% are other. So thank you so much, everyone. We really appreciate you responding to that. And with that, I'll hand it over to Ethel. Thank you.
Thank you, Kiara. Good afternoon, everyone, and welcome to this CLE presentation. The presentation will be broken into 2 sections. So I'll be speaking to the process and relevant information pertaining to the Mental Health Court, and Lorraine will be talking to you about the Mental Health Review Tribunal. Also, the law we're dealing with is subject to Queensland legislation, so we won't be looking at law relating to the operation of courts or tribunals outside of Queensland, which is helpful. It looks like everyone who's tuned in is from this state in any event. So we'll give you a bit of an overview about the Mental Health Court and Review Tribunal because it's very difficult to support persons in those jurisdictions without that overview. We'll also talk to you about appeals, how legal aid can help, and we'll talk to you about any other avenues of support too. So from the poll, I can see we've got a mixture in the audience, and I do want to stress at the outset, that the CLE is targeting frontline supports for persons going through the mental health court or the Mental Health Review Tribunal. So although others are attending and you're welcome to attend, I do want to stress that that's the focus of this CLE. If you do find that there isn't enough legal information in today's presentation, we would be more than happy to take calls or emails at another time. So if lawyers or others are requiring further advice, do please reach out so that we can assist you with that as well. Okay, so what is the Mental Health Court? The Mental Health Court decides the state of mind of people charged with serious criminal offences. So just to note here, I will not be discussing how the Magistrates Court decides the state of mind of people charged with simple as opposed to serious offences. That's a topic best suited to its very own presentation. So the Mental Health Court decides whether an alleged offender was of unsound mind when they committed an offence and whether they are currently fit for trial. I will note that the case of murder is special, as the court also decides if the offender was of diminished responsibility at the time of the offence. The Mental Health Court also hears appeals from the Mental Health Review Tribunal, which I will speak to a bit later in the presentation, and it also inquires into the lawfulness of a patient's detention in authorised mental health facilities. So who is part of the Mental Health Court? The Mental Health Court is constituted by judges of the Supreme Court of Queensland. So at the moment, we have a rotation of judges that preside over the Mental Health Court, with Justice Ryan being the current president of the Mental Health Court. The Mental Health Court also comprises of assisting clinicians, and there are usually 2 assisting clinicians that sit during a hearing. So judges are lawyers, they're not doctors. So the assisting clinicians advise the court on the meaning and significance of clinical evidence and issues relating to the treatment and detention needs of people under the Mental Health Act. Being a court, there are of course always lawyers. So there will be lawyers representing the accused, lawyers representing the Director of Public Prosecutions, the Office of the Chief Psychiatrist, and sometimes also the Attorney General. There are also often other experts like psychiatrists or psychologists or others with relevant experience who will come to court to give evidence. Victims of crime and their families or associates are not parties to the proceedings. However, victims or concerned persons can provide written submissions to assist the court in making a decision. So it's important to note that the Mental Health Court only deals with serious offences or associated offences. So those are offences that are associated with a serious offence. There are some definitions for you there on the screen. What I would like to flag is that there is a separate process for persons charged with only simple offences in the Magistrates Court. And those persons might be of unsound mind or might be unfit for trial as well. But as I mentioned earlier, I won't touch upon those proceedings that happen in the Magistrates Court today. The Mental Health Court only considers serious offences or offences associated with serious offences, and it does not consider Commonwealth offences. And so one of the key take-homes I'm recommending is that courts and tribunals do get legally complex. So if you are supporting someone with a mental illness or a cognitive impairment and they have been charged with a criminal offence, please do get them some legal advice. You can book in for advice with legal aid, and Lorraine will be speaking a bit more to this later about the available services in this regard. So how did matters get to the Mental Health Court? Under the Mental Health Act of 2016, criminal charges can be referred to the Mental Health Court by the accused person or their lawyer under their instructions, by the Office of the Chief Psychiatrist, by a Director of Public Prosecutions, by a magistrate, or by a judge of the District or Supreme Court. And it's important to note that there are different requirements depending on who is making that reference. So whilst there are different requirements to referring a matter to the Mental Health Court, generally referrals will need to be accompanied by a report or supporting material prepared by an expert. So this can be a psychiatrist, it can be a psychologist, a neuropsychologist, or even a clinician who prepares a supporting court liaison service report at the magistrate's court level. The report can be commissioned privately by a person or their lawyer, or it can be requested from the chief psychiatrist in certain circumstances. For example, where a person is already subject to involuntary treatment under the Mental Health Act. So they may be subject to a forensic order, a treatment support order, or a treatment authority. I imagine that some of you attending today will be familiar with that terminology as well. When considering obtaining a report, there are some important things to realize. If a report is commissioned privately by an accused person or their lawyer, the report can be funded privately, or if the person is legally aided, it can be funded by legal aid. Generally speaking, an independent psychiatrist selected by a person or their lawyer will prepare that report, and it is subject to lawyer-client confidentiality, so it doesn't have to be presented to the court. In contrast, for reports requested by the Office of the Chief Psychiatrist, they can also be requested by the person or their lawyer, but they can be requested by a number of other people. They can be requested by the person's nominated support person, the person's guardian, the person's attorney if they have a power of attorney, or the person's parent if they are a minor. The report is then prepared by a psychiatrist nominated by the chief psychiatrist, so it's not a psychiatrist of choice. It's almost always prepared at no cost to that person, but it's not subject to the same privacy requirements as the ones commissioned by a private psychiatrist. And as mentioned earlier, magistrates, judges, and the Director of Public Prosecutions can also refer matters to the Mental Health Court under their own relevant legislative provisions. So how can legal aid Queensland help? Let's say you or someone you're supporting is legally aided. They may have a mental illness or a cognitive impairment. What do? So legal aid has a specialist mental health unit team that represents people in the mental health court. The team receives referrals from in-house lawyers and preferred suppliers doing legal aid work, and they assess merit for mental health court representation. So usually what we ask for is a completed legal aid application, because funding in the mental health court is subject to means and merit tests. I will speak to this a bit more at a later stage. The mental health unit will then conduct a merit assessment, which will require the provision of information relating to the charges. So, for example, this can be a brief of evidence or PP9 documents. Importantly, we will require the provision of the expert's report being relied on for the referral. And then if the matter does have merit and the applicant satisfies the means test, so meaning they are of limited means, then the mental health unit will make a referral of the charges to the mental health court and will also provide representation in that court. So it's important to provide a warning here to anybody who is having a matter referred to the mental health court that the process is usually a long one. It's a bit more like a marathon than a sprint. It can take anywhere from 9 months to 2 years for matters to proceed through the mental health court, which can be a very long time, especially if the matter has already spent some time in the mainstream courts prior to being referred to the mental health court. So in this slide, I've set out some steps that occur between referral to the mental health court and the matter actually being heard, which is usually the last step. So as you can see, there's a lot that happens between the referral and the hearing stage. So to step you through it, once a matter is referred, it's reviewed by an assisting clinician, and the assisting clinician will make a recommendation as to whether a further court-ordered examination is needed. If such a recommendation is made, it involves an examination by one or more court-appointed psychiatrists or psychologists to assess the accused person and to prepare a report. After the reports are done, the matter may be mentioned in the mental health court and then ultimately would be listed for a hearing. So this is a very simple flowchart of the mental health court and their referrals at a glance. It doesn't include matters where an accused is charged with murder, which would require a consideration of diminished responsibility at the time of the offence. But generally speaking, What happens is if someone is charged with an indictable serious or associated offence, and it appears that they were of unsound mind at the time of the offence or may be unfit for trial as a consequence of their mental condition, they can be referred to the mental health court. The mental health court will then make a finding. So without getting too bogged down in legal jargon, one of the main things the mental health court will consider is whether there's a substantial dispute of fact. So there will be a bit of an inquiry as to whether there's sufficient evidence to support the elements of the charge and whether or not the accused person actually contests the charges. The court will then have to decide whether a person was of unsound mind or if they are fit for trial. And if they find that the person was of unsound mind or is unfit for trial, there are a number of options. So generally speaking, in cases where the courts find someone was of unsound mind or is unfit for trial, the court will consider the person be subject to either, will consider whether the person should be subject to either a forensic order, mental health, a forensic order, disability, or a treatment support order. The court does have the option of making no order at all, but generally forensic orders tend to be put in place, and this is in order to support the treatment and care of the person, but also to protect the community. So where serious offences have been committed, the court will generally place somebody on an order. So the previous slide was a simple flow chart of the process of referrals in the mental health court, because I acknowledge that some of our audience may not be lawyers. However, there is a more detailed flow chart on the MH Law Queensland website, which provides a more comprehensive summary of the law, particularly the law in the Mental Health Act, and about the findings the mental health court can make. It also provides some information about the relationship between the Mental Health Court and the Mental Health Review Tribunal, which we will be touching on a little bit more later as well as the presentation continues. But in short, the Mental Health Court makes an order like a forensic order or a treatment support order. That is then reviewed by the Mental Health Review Tribunal. I won't delve into this any further. I appreciate many of you are not lawyers, but it is a helpful resource for those who might appreciate a bit more detail. So when matters come to the hearing stage, generally the hearings are one of two types, either contested or not contested. Contested hearings occur when parties disagree about the issues in dispute, and generally it requires oral evidence to be given by the reporting psychiatrists or psychologists. Typically, these hearings can be quite long. They can be from anywhere from half a day upwards and can last for a number of days. If a hearing is not contested and the parties agree on the findings the mental health court should make, it does significantly reduce the need to hear evidence from reporting psychiatrists or psychologists, so it reduces the length of the hearing. It may therefore result in a hearing only lasting an hour or so. So we thought we'd introduce a running scenario to assist you in thinking about certain instances that might occur and that might be relevant to how you'd support a person who might be going through the mental health court or the mental health review tribunal. So in this first part of the running scenario, we meet Joe. Joe has been charged with a serious indictable offence that has been successfully referred to the mental health court. The matter is now listed for hearing in the Supreme Court in Brisbane, and Joe is worried about who will be present in court. So the question is, which of the following groups can attend the court hearing? The victim and or their family, visiting students, the media, or all of the above? So the answer, I won't give you too much time to think about it. The answer is all of the above. Proceedings in the mental health court are open to the public. However, in limited special circumstances, one can apply to have the courts closed for part or all of the hearing. However, it will be important to keep in mind in the lead up to a mental health court proceeding that these hearings are generally open to anybody wishing to walk in and sit in the gallery at the back. So as people who support persons going through the mental health court, it might be helpful to consider whether the person you're supporting might be better off linking into the hearing via video link from their mental health service, instead of attending their hearing in person, for example. All right, so I wanted to make some comments about mental health court hearings in general. The hearings occur in the QE2 Courts of Law complex on George Street in Brisbane. The hearings are more formal, so the lawyers and judges will be wearing suits and blazers or robes and wigs. The accused is generally represented by lawyers, and the accused addresses the court through the lawyers. So the accused generally doesn't speak directly to the mental health court judge who is hearing their matter. Generally, the accused person must appear for their hearing, so either in person, via video link, or on some occasions via telephone. However, there are some exemptions even to this. So if it's in the interest of justice, a hearing may proceed in someone's absence. For example, it may be the case that somebody is really unwell and is in hospital and could be too unwell to appear in person for their hearing. There is a mental health court judge who presides over the hearing, and there are generally, as I mentioned, 2 assisting clinicians who sit up with the judge. There are also a number of lawyers in attendance, representing, as I mentioned, the accused, the Office of the Chief Psychiatrist, as well as the Director of Public Prosecutions. The decision of a hearing is generally immediate, but in certain circumstances, it can be reserved. So usually after a court hears from all the lawyers and hears from any of the experts, the court will then take advice from the assisting clinicians. The judge will then generally deliver an immediate decision, but sometimes it will reserve a decision if it needs a bit of time to think about what the appropriate decision should be. So I'm about to do a bit of a dive into legal terminology, but I do think it's important to understand concepts like unsoundness of mind, diminished responsibility, and fitness for trial, because these are matters that the mental health court has to decide and consider. So I want to first touch upon the concept of unsoundness of mind, which is defined in the criminal code. The definition is a bit wordy and confusing, but basically someone can be found to have been of unsound mind if their mental condition deprived them of one of 3 capacities. The first is the capacity to understand the nature of an act. Second is the capacity to understand they ought not do an act or an omission. And the third is the capacity to control their actions. So sometimes one can be so unwell as to deprive them of all 3 capacities, but the reality is that there just needs to be a deprivation of one of the 3 capacities for unsoundness of mind to be satisfied. For the lawyers who are attending, I know that the court is also precluded from making findings of unsoundness of mind if there is a substantial dispute of fact or if there are issues of willful intoxication. So if there is a finding of unsoundness of mind, it may result in the court making a forensic order or a treatment support order. So diminished responsibility relates specifically to matters of murder. It's defined in the criminal code as well, but in essence, it means that because of a person's mental condition, the person was substantially impaired, but not quite deprived of one of the 3 capacities I've mentioned previously. If a person is found to be of diminished responsibility, this may result in the charge of murder being replaced by the charge of manslaughter and being returned to the criminal courts to be finalized. I've provided a very overly simplified explanation of what is a rather complex legal concept, but I think that's probably the sufficient extent of an explanation for today's presentation. So fitness for trial is not defined in the legislation. It's left to case law to define fitness for us. The definition of fitness comes from the Victorian case of Presser, which sets out the criteria for fitness. Effectively, there are 6 criteria, and if someone fails to meet at least one of those criteria, they can be found unfit for trial. I will canvass them shortly, but I wanted to say beforehand that fitness can be permanent or temporary. So if you imagine someone who is suffering from a mental illness, it can be exacerbated. There can be times when they are experiencing acute psychosis, but after treatment, it can resolve and they can become fit. There are also other situations where unfitness may be permanent. For example, in a person who has a treatment-resistant illness or a really severe cognitive impairment. So there are 6 PRESA criteria. The first is the ability to understand the charge. This involves a basic understanding of the essential facts of the charge and the elements of the offence. The second is the ability to plead to the charge and to exercise the right of challenge. So the person must understand that a plea of guilty is an acceptance that the essential elements and facts of the offence are established. The third is a person's understanding of the nature of the proceedings. Namely, that is an inquiry as to whether they committed the offence that's been charged, and the person must understand that they are involved in a formal process inquiring into their responsibility for the matter alleged, and they must be aware of the potential consequences of that process. The fourth criteria is a person's ability to follow the course of proceedings so as to understand what is happening in court in a general sense. It's not necessary to understand the purpose of all the various court formalities, but it does involve following the proceedings and understanding the roles of the various participants in court. The fifth criteria is the ability to understand the substantial effect of the evidence that may be given. So the person must have an awareness of the implications of the prosecution evidence. And the final criteria is the ability to make a defense or answer to the charge. So the person must be able to give the court a basic version of the facts as they claim them to be, and this can be, if necessary, through their lawyer. They have to understand that by entering the witness box and responding to questions in evidence in chief and cross-examination, what the consequences of that could be as well. There is also another matter to be considered with respect to fitness. So fitness for trial was previously defined in the old Mental Health Act to include the ability to endure a trial without serious adverse consequences to the defendant's mental condition becoming likely. So if the defendant was likely to become unfit at some point in the trial due to their impairment, then they would be considered to be unfit. Although this consideration doesn't appear in the current Mental Health Act, it is still present in case law, and so it is still relevant to consideration of fitness. So if the court finds a person to be unfit, be it temporary or permanent, the court can then place the person on a forensic order or treatment support order. So what happens if you disagree with a mental health court decision? It does happen. There is an avenue of appeal to the Queensland Court of Appeal. So if there is an error of law, one can appeal to the Court of Appeal, but time limits do apply. People can be self-represented in the Queensland Court of Appeal, but they can also seek legal representation. Legal aid can fund representation in the Queensland Court of Appeal, and this funding is means and merit tested. Additionally, if a person is found to be of unsound mind but is fit for trial, and they are not happy with the decision of the mental health court, they can elect within 28 days of the mental health court's decision to proceed to a trial by filing a notice in the relevant court. So if a person really wants their day in court, there is that option, and it's an alternative limb to appealing a decision to the Court of Appeal. So I'm now going to hand over to Lorraine to speak to you a bit about the Mental Health Review Tribunal.
Thank you, Ethel. So this is a good opportunity to canvass how the Mental Health Review Tribunal operates. The Tribunal is a statutory independent body which primarily reviews the involuntary status of people with mental illnesses and/or intellectual disabilities. There is a link included on this slide to the Tribunal's website, which is designed to assist lawyers, support persons appearing in and before the Mental Health Review Tribunal. So it is a really informative and detailed website, which is there to help a person, as I say, travelling through the Mental Health Review Tribunal and also supporting someone in this jurisdiction. So who is part of the tribunal? Well, the tribunal consists of a president, deputy president, and other members who sit on the tribunal panel and make decisions. These members include lawyers, psychiatrists, and other persons who are community members. Now, the tribunal is formed by a panel, which always consists of a lawyer, who is referred to as a legal member and leads the panel, psychiatrists, who are called medical members, and other members with relevant qualification called community members. So depending on the hearing, sometimes a tribunal can have 2 legal members presiding. This could be for a prescribed offence, such as murder. And the tribunal conducts hearings around Queensland, which is generally in person, but can be from time to time by way of video link conferencing. Now, the tribunal operates under the Mental Health Act 2016, which came into force in 2017. So when the tribunal makes decisions, it must consider the objects and principles that underpin the Act. So the objects are there to improve and maintain the health and well-being of persons who have mental illnesses or those who do not have capacity to consent to treatment. And enable people to be diverted from the criminal justice system and protect the community. And the objects are to be achieved in a way that should safeguard the rights of the person, are least restrictive of the person's rights and liberties, and promotes the recovery and the person's ability to live in the community without involuntary treatment. Now, the Mental Health Act also contains a number of principles that must be considered by the tribunal when making its decisions. The list of those considerations and principles are quite extensive, but it includes matters like recognising the human rights of a person with a mental condition and the role of support persons. And there are specific principles for Aboriginal and Torres Strait Islander persons and minors, because this Act captures and deals with both adults and minors. There are also matters to be considered when making a decision, which include the participation of people subject to an order and support from family, carers, and support persons. So under the Mental Health Act, the tribunal has a number of powers to do a lot of things. So it conducts reviews of things such as treatment authorities, forensic orders, and treatment support orders. It reviews fitness for trial reviews. So I'll just mention that when the Mental Health Court finds a person to be temporarily unfit for trial, the tribunal reviews the unfitness periodically to assess if the person has become fit for trial. The tribunal also conducts reviews of detention of minors in high secure units, whereby the tribunal will consider if the minor can be treated and cared for in an authorised mental health service instead of a high secure unit. The tribunal can hear applications for examination authorities, the approval of regulated treatments such as ECT, which is a shorthand way of saying electroconvulsive therapy, and non-ablative neurosurgical procedures. So what is it, you might wonder? So it's a procedure where an application is made whereby surgeons and psychiatrists are running clinical trials for approvals to put devices into a person's brain. It is a device implanted that doesn't involve damaging or removing brain tissue. And the electrical devices provide a stimulation to control psychotic symptoms for conditions such as obsessive compulsive disorder, which can be treatment resistant and very debilitating for people. So the tribunal will also hear applications for patients in and out of Queensland. And this could be where a person subject of an order wants to move closer to their family who live, say, in New South Wales. Now, the tribunal will also hear appeals against decisions by the chief psychiatrist or the administrator of an authorised mental health service. The decision could be to transfer somebody or a decision to exclude somebody from a mental health service. Now, hearings are generally periodically reviewed every 6 months for such as forensic orders and treatment support orders. So applications can be made at any time by the person subject to involuntary orders, and it can be made by an interested person, Attorney General, a chief psychiatrist or director of forensic disability, or whoever is a relevant a party involved. Also, the tribunal can initiate a hearing by themselves. So an example of that could be a case where the tribunal says in a forensic order review, for whatever reason, they might think that it's more appropriate to review a forensic order in 3 months, as opposed to a periodic review in 6 months. So now I'm going to talk about the ways that people can be supported during and after a hearing. So the second half of this presentation is going to break down how to approach the jurisdiction, breaking it down into 3 sections. So we're going to start at the notice of the hearing, who can attend the hearing, self-reports, clinical reports, and other documentation and representation. I'll then talk about what goes on during a hearing, and then after the hearing, the notice of decision, the statement of reasons, and getting further advice or assistance. So when supporting a person through the hearing process, it's important to understand the jurisdiction in which the tribunal operates. The tribunal operates as an inquisitorial model rather than an adversarial model. The jurisdiction is therapeutic in nature, there to support the person and achieve the best health outcome. Where possible, work should be done within the recovery framework. This places a person who is subject of a proceeding at the centre of the decision-making process, and it's supported through collaboration with stakeholders such as treating teams and support persons. So a big thing to realise about the jurisdiction is that successful outcomes are individualised, and it's really important that those outcomes support a therapeutic alliance with the person's healthcare professionals, and it's really important not to damage that relationship. It's therefore important for us as we try and support the person's rapport with the treating team, because I think anyone who has practiced in the tribunal realises that better outcomes are achieved through a collaborative approach rather than an adversarial approach. So a win can be improving communication with the treating team, making progress towards discharge from hospital, or increasing community treatment, or encouraging the treating team to review or change a treatment plan. Now, again, it's important when approaching the jurisdiction that people who come before the tribunal come from diverse backgrounds with varying degrees of disability. So we do need to be mindful of these matters to ensure that we provide people who are subject to proceedings an opportunity to participate in the process. So if you are a legal representative out there in the jurisdiction, we need to do everything possible to enhance the person's capacity to participate. And I should say, yes to guardians and support persons equally. They play an important role in the process. And I should say in a very important role at that. So there are a couple of slides now dealing with notices of hearing. So you can anticipate that hearings are going to occur periodically, which is, as I said, every 6 months. So the notice of the hearing will generally provide details of the nature of the hearing, when and where the hearing will be held. It will also give some detailed information about the rights of the person subject to the hearing. Who receives a copy of the notice will depend on the type of hearing. For example, persons subject of an application of an examination assessment are not issued with a notice of hearing, because then that would effectively give them knowledge of the examination. Now, the tribunal is bound by the rules of natural justice and procedural fairness. So therefore, parties to the proceeding have to have written notice of hearings within sufficient times prior to their hearing itself. So as you can see, the notice of hearing may be given to a number of parties. The person subject to the review or an application or appeal, the applicant, the administrator or chief psychiatrist, director of forensic disability, attorney general, and the legal representative for the person. So the time period that is allowed will depend on the hearing type and can range in timing. For example, notices for electroconvulsive therapy emergency applications must be 3 clear days prior to the matter being heard. Otherwise, it's generally 7 days prior to the hearing. So a person subject to an involuntary order can also be accompanied to the hearing by one member of their support network or more than one person with the permission of the tribunal. They can have appointed up to 1 or 2 support persons who can obtain a copy of the notice of hearing. Again, it's going to depend on the type of application and who is involved with that. So notices can be given to the guardian or attorney or an attorney. If you're either of these supporting someone in the tribunal, it's important that you inform the tribunal of your appointment. So who can attend a hearing? There are a variety of people that can attend. This may include a nominated support person, family member or carer, or other support person. Now, I think the important thing to realise is that tribunal hearings in the Mental Health Review Tribunal are not open to the public unless the tribunal otherwise directs, which is a different position to hearings in the Mental Health Court. So essentially, the slide speaks for itself as to who can attend a hearing and depends on the type of matter that's been heard. So as I've said, a person appearing before the tribunal can be supported by at least 1 support person or 2 support people with the permission of the tribunal. And it's important to say here that support persons are there to provide support only and not representation. So we've got a scenario here. Joe is 25 and doesn't want to attend their hearing without their good friend Sam. So can Sam attend? So the short answer is yes. Sam can attend the hearing with Joe as a support person. However, like I've said before, Sam is only there to provide support and not representation. So essentially, the tribunal can conduct proceedings in the absence of an involuntary patient, but only if the patient is aware of the proceedings and has chosen not to attend, or the patient is too unwell to appear and it's appropriate and expedient to proceed with the matter in their absence. So persons who are subject of proceedings should be encouraged to attend their hearing whenever possible so that they can raise their views directly with the tribunal. This can be in person or by way of video conference. I should say persons who are subject of examination authorities don't attend their hearings because, as I've said before, it effectively gives them notice that they might be subject to an examination authority. So the tribunal also issues written decisions called practice directions, which you will find on the website. These are issued by the President and covers procedural matters, among other matters as well, such as disclosure, modes of attendance, just to highlight a few. So if you're supporting a person in the tribunal, it is important that you review practice directions as they change from time to time. So as of the 9th of December this year, which is only a few days ago, there has been a practice direction which has been issued, providing circumstances which observers might be permitted to attend hearings. So I encourage you all to have a look at that. So moving on to self-reports. If you're a person supporting someone in the tribunal and they don't want to attend their hearing, it's important that they complete a self-report. There is a blank form usually attached to the notices. If not, they can be downloaded from the tribunal's website. It's effectively a questionnaire which prompts the person to provide information which can be relevant to the tribunal's decision. I should say that persons can also provide additional information outside of the prompts in the questionnaires. Self-reports are a good way also to communicate to the tribunal how the person feels about their order. And it's often the case that people find it difficult to communicate in an atmosphere sitting across from members of the tribunal, which can be quite daunting. I'm sure we all know how nerves can get the better of us in situations. So therefore, self-reports are important. So generally, self-reports are completed by a person who is subject of tribunal proceedings. However, support people can help a person complete a self-report. Lastly, I should say that self-reports are voluntary. A person doesn't have to complete one, and a person may also express their views verbally to the tribunal hearing. Okay, so I'm going to talk about clinical reports. So clinical reports need to be provided before the hearing. This is really important. Now, clinical reports are prepared by a person's treating psychiatrist and contain all the relevant information that the tribunal needs to consider for hearing forensic order, treatment support order reviews, and treatment authorities. There are rules about timing for when they must be given to the person, and it's very important that people get them with adequate notice to ensure procedural fairness. So the Act requires that a copy of the clinical report be given to a person at least 7 days before the hearing. So if it's not provided within that time frame, a person may be able to seek an adjournment at their hearing so that they have adequate time to review the report and obtain legal advice. These reports should be discussed with the person subject to the hearing so that they can understand what is being said about them, if you're a lawyer, and matters that are likely to be discussed at the hearing. So that is important for lawyers who are out there. Now, the tribunal also has the discretion to make confidentiality orders if it's satisfied that disclosure could cause serious harm to the health of the person or put someone else at risk. So importantly, clinical reports confidential, and there are strict rules in the Mental Health Act that prohibit the disclosure of confidential material except to specific persons. However, there's nothing stopping a person from disclosing their own clinical report to others. For example, a person may disclose their report to a support worker, family member, or a lawyer for advice. So it's important to remember that these reports contain very sensitive information and should be treated as such. And it's important to note that if you are supporting somebody in the tribunal. So other documents that might be provided as well to the tribunal, it may be the case that you are as a person supporting wants to rely upon a document at a hearing. This may include an independent second opinion that a person has obtained. So one of the fundamental principles that underpin tribunal hearings is natural justice. So the Mental Health Act requires that any person in a proceeding must be given a reasonable opportunity to present their case, inspect relevant documents, and make submissions. Again, reasonable time does need to be given to the parties to consider those documents. So the tribunal requires these documents 3 clear days before the hearing. However, the tribunal still has the discretion to accept material that is provided outside the time frame, and the tribunal will decide each matter individually based on its own merits. So something about victim impact statements. So victim impact statements are something that are not provided to the person subject of tribunal hearings unless permission has been given to do so. So there is a specific section of the Mental Health Act that deals with this, and the tribunal may even order that a victim impact statement not be provided even when permission has been given by the victim or the victim's family. And there are strict rules around the disclosure of these statements and in practice. And it is often the case that statements remain confidential and it is not disclosed to the person subject of the hearing. So moving on to representation. So this is really important. The Mental Health Act does specify that people who are subject to proceedings may choose to be represented by a nominated support person, a lawyer, or the person at the hearing. So it's really important that somebody who represents a person at a tribunal hearing, that they must express or represent the person's views, wishes, or preferences, or to the extent that they cannot be expressed, then represent the person's best interests. So this is a fundamental rule for representing someone in the tribunal. So whether a lawyer acts on instructions or represents the person's best interests will depend on the person's capacity to provide competent instructions. And a lawyer is required to conduct a detailed capacity assessment in order to make that determination. So given the target audience, I think I might leave that one there. So there are fact sheets available for representing people in the tribunal. So if you are a nominated support person, there are resources from Queensland Health which are really helpful and which have been published, and they're on their website. So in all matters, the tribunal has a discretion to appoint a legal representative to certain matters, and I've listed a number of these. Here the tribunal must appoint legal representative for tribunal matters if they think it would be in the person's best interests. For example, an adult on a treatment authority who may suffer from a serious disability and may have limited communication skills, then it may be the case that the tribunal may consider it's in the person's best interest to appoint a lawyer. So if you are a lawyer out there or who has done the requisite training required, then you might have already had the opportunity of appearing on some of these matters before the tribunal. Now, where a lawyer is appointed by the tribunal, it's at no cost to the person. So if you're supporting a person who is concerned about legal fees, you can reassure them that they will be represented free of cost. So essentially, there is a process to this appointment. The tribunal will contact legal aid, who will then organise a lawyer, either from legal aid or otherwise it might be a preferred supplier. Generally, legal aid tries to maintain consistency with legal representation so that a person gets the same lawyer each time they have a hearing wherever possible. Legal aid also tries to organise a lawyer from the person's local area. However, sometimes this is not possible. And in these circumstances, a lawyer may have to appear at a hearing by telephone or by video conferencing. So lawyers are appointed by the tribunal and are independent. So lawyers appointed by the tribunal are independent from Queensland Health and the tribunal. So once appointed, lawyers will contact their clients or people appearing before the tribunal before their hearing and speak with them and obtain their instructions in accordance with their views, wishes and preferences, or where possible, best interests. So one of the great challenges we often face as lawyers is trying to locate our clients. So often we rely on the assistance of social workers, case managers, and non-government organisations to support our clients to speak with us so that we can represent them. So another fundamental issue is that lawyers appointed by the tribunal need permission or consent to speak to other people. This is very important. Now, if a person has been notified of a hearing date and they think they should have been appointed a lawyer to represent them and have not heard from their lawyer, it's really important that they contact the tribunal on the 1-800 number on the slide, who can assist them with their inquiry. So this slide deals with the disclosure of personal information by the health service. So now there are certain rules about disclosure of personal information by a health service. And as legal representatives, we have from time to time come across services who have been reluctant to provide us with any information relating to a client, even if it might be to confirm their contact details. So The Act specifically allows the release of some confidential information to a lawyer appointed to act in these proceedings. So in terms of legal representation, there are standards and guidelines that need to be adhered to. So lawyers appointed to represent persons in the tribunal must be accredited by Legal Aid. Legal Aid have case management standards and best practice guidelines, and they're available on the website. So we have a scenario about Joe. Joe has been appointed a lawyer by the tribunal and feels more comfortable using a friend of hers who is a lawyer. So I'll answer yes to the question. Joe can choose not to be represented by the tribunal appointed lawyer. So what happens if a person doesn't want to be represented by the appointed lawyer? Essentially, you're at liberty to refuse them. So the person can request waiving a lawyer, and this can be done by sending a written correspondence to the tribunal at the locations on the slide. A person can also tell the tribunal at their hearing that they don't want to be appointed, that they don't want the appointed lawyer to represent them. But this is qualified by the fact that the person must be an adult and they must have capacity to make that decision. So that means that minors and adults lacking capacity cannot waive their right to the appointed lawyer. So how does all this work in practice? So where the tribunal has received written notice that a person intends to waive their right to representation, or they've been told there will be a preliminary hearing before the review starts, the hearing starts to decide the issue. So the lawyer who is appointed is still required to attend. The tribunal will then hear evidence from the treating team as to the person's capacity to make the decision to waive their right to the lawyer. They'll also hear directly from the person if they attend and the lawyer's representative. And if the tribunal decides that the person does have capacity to waive legal representation, then the appointed lawyer will then be excused from the hearing. If the tribunal decides that the person does not have capacity, the lawyer will remain. And this may mean that the hearing is adjourned up to 28 days to give the lawyer some further time to engage with the person, or if the person doesn't engage, then they will be represented in their best interests, the client's best interests. So an independent patients' rights advisor can assist patients who don't want to attend, who don't want an appointed lawyer. They can seek assistance from that person or their case manager to provide the waiver to the tribunal or inform the tribunal in person. I should say that the independent patients' rights advisors are valuable in this regard, as well as other supports that they provide, which I've mentioned a few times in this presentation. I'm not going to delve into detail with this slide, but I think it speaks for itself. But suffice to say that the Act expressly provides that independent patients' rights advisors are there to advise patients and nominated support people about their rights. So all authorised mental health services must have systems in place to ensure that patients are advised of their rights under the Act. This provides an avenue for patients to immediately engage and seek assistance. So it's not a requirement under the Act for private authorised mental health services to engage independent rights advisors. And as you can see, there is a link to a fact sheet which sets out their role on how to advise patients and support persons, families, carers about rights under the Mental Health Act. So there are some slides here to deal with the conduct of hearing. Now, tribunal proceedings are a lot more relaxed and less formal than hearings conducted in the mental health court, where the lawyer speaks on behalf of the person. So the tribunal really does like to have the person subject of the proceeding present, because they really like to speak to the person making inquiries to the person directly when considering the safety and welfare of the person, including the safety of others and the person's mental condition. So for example, a review of a treatment authority, forensic order or treatment support order will generally be constituted by 3 or 5 members. So essentially, now we will look at the conduct of hearings. So each panel conducts hearings on the way it sees fit, and all material disclosed to the tribunal allows them to properly consider each case. So there are rules which must apply, and these apply to the tribunal, which is that they must act fairly and in accordance with the merits of each case. Also, like we've heard before, the tribunal doesn't operate like a court, and it's not bound by the rules of evidence. So the tribunal may inform itself of any matter in any way it considers appropriate, and that all relevant material needs to be disclosed to the tribunal for it to decide a matter in accordance with procedural fairness. So no panel will operate the same, but generally this is how a panel will operate in making its decision. The panel explains the procedure and introduces themselves. Questions are directed by the tribunal panel to the person if they're present or on video conferencing, and questions are directed by the tribunal panel to the treating team. So the Attorney General will be given the opportunity to ask questions of the treating team, and the legal representative is then given that same opportunity to ask questions of the treating team. And then the Attorney General makes submissions, and the legal representative will do the same, either reflecting views, wishes or preferences, or acting in the person's best interests. So finally, then the panel will deliberate, parties will leave and be invited back for the panel's decision. At times, the tribunal may reserve its decision and notify the parties shortly thereafter. So just something briefly on the recording of hearings. So as of the 25th of November 2023, the tribunal began electronically recording proceedings. Previously, it had undertaken written recordings of the proceedings. So there are really good information sheets and policy sheets available on the Mental Health Review Tribunal website. So persons can request a copy of the electronic audio recording. They may request written transcripts of the audio recording. However, if you're wanting to know why the tribunal has made its decision, it's best to request a statement of reasons, which sets out the reasons behind the tribunal's decision. So there are times the tribunal can decline recording an electronic hearing. However, the person would need to hear to show that there are compelling reasons not to electronically audio record. So for lawyers out there representing people in the tribunal, or for support persons assisting people in the tribunal, then turn your mind to whether or not there is or is not compelling reasons not to electronically record a hearing. An example could be extreme distress to a person. So on occasion, the tribunal have made the decision not to record a hearing, in my experience. So if you want information or advice about recordings of hearing, don't hesitate to contact our team at Legal Aid, and we can provide more information about this. So I note that we're running out of time, so I will speed up a little bit. So there is some information about what occurs after a hearing takes place. So the tribunal will provide the person subject of the hearing with a notice of the decision. I should say that if a person subject of the hearing wants to know why the tribunal has made a decision, then this is the avenue to request a statement of reasons. So once a request is made, the tribunal have to provide a statement of reasons within 21 days of that request. And this will usually inform people whether or not they wish to appeal the decision to the mental health court. So the statement of reasons can be made to the tribunal by email, post, or by telephone, and I think I've put that slide up there. So there are appeal options also open to the person if they're unhappy with their decision. So I'm going to hand over to Ethel, and I should say a notice must be lodged with the Mental Health Court Registry within 60 days of receiving a tribunal's decision. And now I'm going to hand over to Ethel, who will take us through the process of appealing a decision from the Mental Health Review Tribunal to the Mental Health Court.
Hi all, I'm going to be very brief with this information. I'll briefly explain the process of appeals to the Mental Health Court from the Mental Health Review Tribunal. So if a person is subject to a decision from the Mental Health Review Tribunal and is wanting to appeal that decision, the Mental Health Court will hear appeals of such decisions, and these can also be lodged by the Attorney General. So usually once an appeal notice is lodged with the Mental Health Court, a notice will be sent out to all the relevant parties. I'll just make a key point here by saying I'd strongly encourage people supporting persons who are either wanting to appeal an MHRT decision or are perhaps subject to an appeal of a decision by, for example, the Attorney General, to get some legal advice about their options as soon as possible. Also, when lodging an appeal to the Mental Health Court, there is an option to apply for a decision of the MHRT to be stayed, which basically means for that decision to be temporarily suspended until an appeal is able to be heard in the Mental Health Court. And another important point to note is that although it's being heard in the Mental Health Court, appeal proceedings for Mental Health Review Tribunal decisions are closed, which is obviously different to the usual Mental Health Court proceedings that are determining unsoundness of mind or fitness for trial. So if a person appeals a decision by the tribunal or is the subject to an appeal made by another party, legal aid can provide representation subject to means and merit tests. And the decision of made by the Mental Health Court following an appeal is final. The big thing, as I want to stress, is that findings from MHRT appeals are final. There's no other avenue to appeal those decisions further. I'll now very quickly hand back to Lorraine to tell us about additional ways legal aid can be of assistance.
Yes, and I know we're running out of time. So if you're the person not happy or they want further information or require legal representation in the Mental Health Court or the Mental Health Review Tribunal, please contact Legal Aid. Legal Aid has specialist in-house teams for the Mental Health Court and the Mental Health Review Tribunal that provides advice on all matters relating to the Mental Health Court and Tribunal. So advice is conducted by telephone Monday to Friday during office hours. If Legal Aid are unable to assist, there are other options available, such as referral pathways to community legal centres or private firms. We really want everyone to get the help they need, and sometimes if we're unable to provide that assistance, we can provide a referral that will hopefully be of assistance. So I think we've run out of time, but again, if you have any questions, please feel free to contact either Ethel or myself, and we will do our best to answer your questions. Thank you everyone for attending today.
Thank you so much for that. That was a great presentation, Ethel and Lorraine. Interpreters had to leave, but thank you to them. Just a quick slide. So for general legal information and referrals, our 1300 651188 number is there. We have a specially designated line for Aboriginal and Torres Strait Islander information, which is 1300 650143. And to ask questions about an existing application of aid, please contact 1300 383 900. There are just our office locations, and of course all publications are available for free on the Legal Aid website. You can order them at absolutely any time. Our next webinar will be open for registration soon, so that will be in February. This webinar, along with all of our previous ones, are available for free on the Legal Aid YouTube website. And of course, follow us on Facebook, LinkedIn, Instagram, and X for any upcoming topics, dates, and other useful legal information. Once again, thank you. This was absolutely great. We still have a large number of people still listening. So thank you everyone too, to our wonderful audience for your engagement today. And we will see you again in 2026. Have a safe and happy holidays.